All right, you are Tadesha Eli, and Miss Eli was previously in court, entered pleas of true to a motion to revoke probation on probation for injury to a child, elderly, or disabled individual. Entered pleas of true to counts 1 through 8. I've received an updated report. Has everyone had an opportunity to review?
Right out of the gate, this is serious. Injury to a child? That's not a minor technical violation. That's one of the most emotionally charged offenses in any courtroom. And when someone pleads true to a motion to revoke probation, they're essentially admitting they violated the court's trust. Legally, that gives the judge broad discretion. At this point, the odds are already shifting. The big question is this a second chance moment or the final straw?
That report. Are there any additions? All right, thank you, Ms. Lopez. And there was not an agreement, correct? Mr. Lewis, you may proceed.
Early on in the during the sort of way um it seemed to work out and then and because you try to do that on track when they can do that on board and that's when they started to go down here and snowball. Since he's in custody, he has to secure the situations with a brother. They will be here for decided to be reinstated. Also, she has woman up that makes the main problem. You understand what she's already you are in search of these doctors say this private who when I talk about the situation is also one of the jobs. And she has worked for a while, early on, but full of heart and it's like so that's just what it comes down to. Try to see if you can like be out in probation.
Notice what the defense is doing here. This is classic mitigation strategy. Paint a picture of instability, not criminal intent. Housing issues, employment instability, snowball effect. The argument? She didn't fail because she's dangerous. She failed because life unraveled. But here's the tension. Probation isn't just about intention. It's about compliance. So the real question becomes, how many setbacks does the system tolerate before accountability outweighs sympathy?
What's the status of the Duck Ranch, the new offense?
Well, you know, so yeah, remember,
But it's Miss Malfino. Yes, I think it's said that we're not here on a doubt. Probation also give having the opportunity to support where very good they're not done. So, Ms. Eli, the issue that The problem that I have is that when you first got on the probation, we sent you to the cognitive track of ISS so that you could get told to be able to be successful and do better and make it through probation. And when you got out of ISS, you were put on the high medium caseload. You have to help with all of these issues that Mr. Lewis helped with, like to live and with jobs and issues. You were given all. So for me to say, okay, you've already been given all that and you didn't take advantage of it, give you some other opportunity and let you out when I've already given you these sanctions, the underlying case is just very, very serious. And the fact that you got a probation was a big chance. And if you hadn't already been to ISF, then maybe I'd be thinking about, okay, let's do ISF. Let's do something to give you some tools to do better. But you did that, and you didn't take advantage of it. So this time I'm going to find that you entered completely true to counts 1 through 8 freely and voluntarily. Find this counts true. Find sufficient evidence at this time to find you guilty, and at this time find you guilty of the offense of injury to a child. Sentence you to a term of 4 years in the institutional division.
And there it is. For years. Here's what's legally significant. The judge emphasized prior interventions, ISF high-level supervision, structured support. In revocation hearings, judges often ask themselves one thing. Have we already tried the tools? In her view, they had. This wasn't about one slip. It was about exhausting options. For the audience watching, do you think the system gave enough support? Or was this accountability long overdue?
Department of Corrections. You will receive credit on that sentence for any time that you've been in custody, but the law gives you the right to proceed. This is not a plea agreement, so you do have some rights to appeal. You can talk to Mr. Lewis about that. I'm handing you the trial court certification. It shows you do have that right to appeal. I need your signature on that. I'll give you a copy of it. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under law to possess a firearm or ammunition. Possession of a firearm or ammunition can lead to charges against you. Firearm is a legal term. You should read the written admonishment you see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, about how long that lasts you. Alright, you can find that in the bottom of the box. Say Leonard Guillory. Right now. Looks like August 27th. It should be the one. Good morning. Are you Leonard Guillory? And so, Mr. Guillory, let's start with cause number 25. Hold on. Yeah. All right. In cause number 25, DCCR 0902, you're charged with aggravated assault with a deadly weapon from June 19th, 2025. The indictment alleges that you were previously convicted of a felony offense, which means for punishment purposes, if you were found guilty, you would be considered a first-degree enhanced, and the minimum punishment would be 15 years, up to 99 years for life. You understand?
Let's break this down. First-degree enhanced is courtroom language for your past is about to matter a lot. Prior felonies can dramatically increase sentencing ranges. That 15 to 99-year span, that's massive leverage for prosecutors in plea negotiations. So when the state offers 10 years and the defendant rejects it, that's a gamble. High risk, potentially life-altering risk. Would you roll the dice on a trial with those stakes?
And I have a plea bargain rejection here on the tablet that you signed with Mr. Lewis that shows the district attorney's office made an offer. He wanted to enter a plea of guilty for a 10-year term in prison that would run at the same time as a 10-year term in that probation. You have every right to reject this offer and have this case set for trial. I do want to make sure you understand what the possible consequences are and what your options are. And do you want to reject that offer and have that case set? So what we're going to do now, Ms. Hillary, is go through that motion. We're going to get pleas of true or not true on that motion, and then we'll have a hearing on that motion first at a later date. I'll make a decision on that motion, and then we'll go forward with the trial. Okay? So will you waive the formal reading of the motion? In clause number 22-4098, have a second amended motion to revoke your punishment for probation. Shows that you were placed on probation June 26, 2024 for unlawful possession of a firearm by a felon, a third-degree felony, and that was a 7-year deferred probation. Is that correct? Speak up, please. Thank you. And it alleges that you violated your probation. Count 1 alleges that you committed the offense of burglary of a vehicle June 8, 2025 in Hardin County, Texas. Is that true or not true? I'm sorry. Count 2 alleges that you failed to immediately report the arrest from June 8, 2025 to your probation office. Is that true or not true? Count 3 alleges that you failed to provide verification of performing the community service hours. And is that true or not true? Count 4 alleges that you failed to provide verification of participating in an education program for your GED. Is that true or not true? Count 5 alleges that you failed to provide verification of entering and successfully completing the moral recognition therapy, the MRT. Count 6 alleges that you failed to pay your court-assessed fees as directed. As of June 16, 2025, you were $1,140 behind. Is that true or not true? And then it says second amended, but never said first amended, so I think it's probably all. Anyway, count 7 alleges that you committed the offense of aggravated assault with a deadly weapon June 19, 2025, and is that true or not true? Count 8 alleges that you committed the offense of evading arrest and detention with the use of a vehicle June 19, 2025. Is that true or not true? Count 9 alleges that you possessed a firearm on June 19, 2025 in violation of your deferred adjudication order. Is that true or not? So did you enter your plea of true to count 6 freely and voluntarily? Alright, then I'm going to find that count true, find sufficient evidence to find you guilty and revoke your probation. I'm not going to do that today. I'll reset it for the hearing and ask the probation department to do an updated report. Mrs. Coleman, does the state anticipate witnesses with regard to those part of the offenses that are alleged? So we'll set it on a date when we're not in trial, not a different date. We have time to have that. Alright, you can go back with the bed. Good morning. Are you Raymond Sweet? And Mr. Sweet, in cause number 25, DCCR 1531, you're charged with the first-degree felony offense of burglary of habitation with intent to commit another felony, and that's from August 22nd, 2025. Your indictment alleges you were previously convicted of burglary of a habitation May 28, 1987, and also burglary of a vehicle on that same day. And then after those were final, you were convicted of robbery April 20th, 1988, and also burglary on that same date as well. And then after all of those were final, you were convicted of aggravated assault of a correctional officer June 8th of 1992. What that means is that if you go to trial and you're found guilty and those prior offenses are true, the range of punishment in your case would be between 25 years and up to 99 years for life. Do you understand? And I have a plea bargain rejection here on the tablet that you signed with Mr. Rojas that shows that the district attorney's office made an offer if you wanted to enter a plea of guilty for a 30-year term in prison. You have every right to reject that offer and have your case set for trial. I want to make sure you understand what the possible consequences are if you go to trial, what your options are. Do you understand all of that? And do you want to reject that offer and have your case? I'll get that done. I do want to make sure, Mr. Smith, is there any reason to believe that there's any other evidence that that offer would change? So I want to make sure you understand that I will not accept that offer today. If you change your mind and you want to enter a plea of guilty, then it would be something different open to the court. Also, so do you want to go forward with it? Okay. Mr. Rojas.
This moment is pure courtroom tension. A 30-year offer on the table. The judge makes it crystal clear. It's not going down. Reject it now, and you may never see it again. That's strategic pressure. Some defendants bet on trial hoping for acquittal. Others miscalculate the strength of the evidence. The psychology here is fascinating. Is this confidence, desperation, or belief that the state can't prove its case? Because once that door closes, it slams.
Us has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I could release him and appoint someone else today who could begin preparation for trial. Is that okay? So, Mr. Rojas, you're released. We will appoint someone today. They should be out to see you very soon to begin preparation for trial. All right, we can go back with the case. Yes, sir. Good morning. Are you Deshaun? Is it Vital or Vital? Vital. And Mr. Lewis, we are client with a formal reading of the indictment in this case. Mr. Vital, in cause number 25, DCCR 1107, you're charged with first-degree felony offense of aggravated robbery on July 10th, 2025. How do you plead to that? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they told you? And then in cause number 25, DCCR 1109, you're also charged with the first-degree felony offense of aggravated robbery from July 10th, 2025. And how do you plead in that charge? And are you pleading guilty freely and voluntarily? And again, because you did what they told you. In both of those cases, I have here on the tablet documents that have your signature on them, the date is marked as exhibit number 1. Before you sign these, you go over them with you. Do you fully understand? And do you understand if I follow the agreements that you've made with the district attorney that you'll be waiving or giving up any rights? And it looks like the agreement is for a 10-year deferred probation that ISF would be ordered. So when is your 18th? Okay. So it'll be less than that at the end of the year. So we'll do upfront time until your birthday, and then you would go to ISF. That's your understanding. Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in deportation, exclusion from admission to the country, or denial of naturalization under federal law? Contenders number 1, submitted. Is there any evidence that the title is not competent? All right, sir, I'm going to find that you entered your pleas of guilty in each of your cases freely and voluntarily. Find that you're mentally competent, you understand the nature and the consequences of your pleas. Find sufficient evidence to find you guilty. However, I'm going to restate your case of sentencing so that the probation department can do pre-sentence support. That'll give me more information about you and your case, and we'll come back later. So, are you at Minnie Rogers or at the jail? Yeah.
Obviously, while he's producing press conference, you mentioned what there are a couple of
Yeah, I don't see any at all.
It's not the ones that are you can't find him. The last night I saw was he moved on the door and
Yeah.
One of the one in the what this report now since
Sure, thank you, Mr. Nichols. And I was going to address that. You may have heard out there already that incident report at the jail don't go over very well with me. I do understand there's some things going on that weren't you're doing, so you just keep doing what you need to do. Keep your head down, make it really good for something, so that you can be successful. Doing the right thing. If we end up with support, change your behavior, which I don't see any reason to, doing pretty well. And it sounds like the jail has taken notice of what's going on and where you can be. But just continue doing what you're doing so that when we get back here in a few weeks for sentencing, I don't have any issues. That's the issue to look at with regard to jail. Okay?
This last case hits differently. Deferred probation means a conviction isn't final. It complies. It's a second chance, legally speaking. But notice how the judge zeroed in on jail behavior. Even before sentencing, conduct matters. Incident reports can influence final outcomes. That's the hidden layer of the justice system. Your record isn't just what you did before court, it's what you do while waiting. So here's the takeaway. Second chances exist, but they come with microscopes attached.
All right, we can go back with space.